Well, good morning, everyone. Thomas Montgomery. It's a beautiful Monday morning, February 6, 2023. We get together with our distribution partners most weekday mornings at this time, talk about strategies, tips, techniques, share success stories. Today is a more in-depth, more involved training than we typically go through. It is an overview of a full curriculum that we have that I thought you should be aware of it. Sorry. If you are an affiliate, you're welcome to stay on the training, but it really doesn't matter much to you. But if you're a white label partner, or I guess I would argue if you're a business owner in any industry, you know that your goal is to make profit, and to make profit, you have to make sales, and to make sales, you have to collect money. And unfortunately, we live in a society where sometimes people don't pay the money that they owe. And so we need to have a plan for that. So most relevant to what you and I do together, if you're a white label partner, you might have a client that comes aboard and that doesn't pay as promised. Maybe they quit, so they're not participating, so they breach the agreement. Maybe they are not accepting first tranche financing, so they're not paying their refundable deposit, which is a breach, so they owe you money. Maybe they've received funding and they didn't pay you, which didn't happen too often, but could. And so that's a breach. So our topic today is about what to do when people owe you money and they won't pay you what they owe you. So in our world, we have to deal with this. Sometimes we have white label partners. They sign up and then they don't do what they promised to do. They breach. Sometimes we have clients that sign up with us and they don't do what they promised to do. But if you're a business owner in any industry, this is probably relevant, but it's especially relevant if you are a white label partner, because chances are you're going to run into instances where people don't pay as promised. So we put together this curriculum, and I wanted to go through the overview with you, and then I'd like to get some feedback. Is this valuable? Is this something that you would like to go through? And if so, we can figure out how to accommodate that. So our topic is business litigation, creditors' rights. So if you're the one that is owed, you're the creditor. So if you own the bakery and the people take the muffins and they don't pay, then they're the debtors and you're the creditor. If you're a white label partner and you have clients that haven't paid, they're the debtor, you're the creditor. So it's important that you get in the mindset that you are the CEO of your business. You're responsible for your P&L, profit and loss, and making sure that you collect the money that's contractually owed to you is the responsible thing to do. You might argue if you're not going to do that, you're probably not in the right role. You probably need to hire someone to fill that role, CFO or what have you. So we're going to go through this 14-class curriculum and talk about how to collect money that is owed to you. So we start with class one. Class one is really getting the client contract right. We've talked about for our white label partners, we recommend getting an e-signature, having a landing page and allowing clients to sign online because that is convenient. But of course, when you do that, you want to do it in such a way that it's a binding agreement. So this training, the description is as follows. In recent years, electronic transmission of critical business documents has been increasingly prevalent. According to DocuSign, a provider of electronic signature services, 95% of organizations are using or plan to use e-signature programs to facilitate their needs. So this is a big deal. If you're not using e-signature as a white label partner, you probably should be at least considering it. And how you do it affects the collectability. And so that's what this training is about. It's imperative for those employing this technology, meaning e-signatures, to be vigilant to ensure compliance with all applicable statutes and regulations to ensure the enforceability of documents executed. This program outlines the legal landscape and identifies potential pitfalls for businesses and others. So this is class one, making sure that we have good enforceable contracts. Make sense? because that's the first step to enforceability. Now, we do realize that not all of you are attorneys or even paralegals, so we wanted to then have a class that kind of gave you the big picture view. So class 2 is focused on helping non-business litigators about the essential skills that you need to litigate a business-related matter successfully. Now, as you know, we have a litigation practice, so if you want us to litigate it for you, we can, but this isn't some pitch to do so. This is to better prepare you to do it yourself if you want, or to better understand what we'll be doing for you if you choose to use us. The program will cover the business litigation process, starting with negotiations, mediation, arbitration, filing the summons, complaints, discovery, motions, and trial. So class 2 is great for those of you that maybe have not been as involved in the litigation process in the past. And we got a number of you joining late, which is fine. What we're covering today is business litigation, creditors' rights. Because if you own a business, chances are people will owe you money. And some people that owe you money may not pay as agreed. So this is a curriculum of multiple classes to help us be better prepared to collect the money that's owed. This represents what we do in our litigation practice against those people that harm us or breach contracts against us. And it's probably useful for you as well, probably for any small business owner, unless they have a fully cash business at time of sale. All right, and then we get to class 3. Class 3 is called front loading the litigation, the keys to pretrial advocacy. So in a book called Pretrial Advocacy from 2021, these attorneys and authors talked about the pretrial processes being front loaded. So they explained changes regarding the pleading, certification, discovery, summary judgment using expert witnesses. And so those things have changed. So what we're going to learn from this is to understand the evidentiary and procedural rules for the pretrial process, how to think about the early stages of your case to be better prepared, and practical approaches. And again, if this seems like a little bit too much, you may want to outsource your collections. But if you want to roll up your sleeves, or you frankly just don't have the financial resources to outsource it, good information. Let's move on to class 4. We want to go ahead and build a strong foundation of debt collection. Because again, it doesn't matter if you're a child care center and you have a parent that has a child that attends your school that doesn't pay. It doesn't matter of the industry. Nearly every industry will run into debt collection issues. People that owe your business money. So here we're going to talk about FDCPA compliance, collection techniques, and more. We realize that collecting debt can be challenging, time-consuming, and a risky process even after the judgment is granted. So just for your reference, if you're a little greener with this, judgment can happen from a motion for summary judgment before trial or after trial when you win and then you get a judgment. But in other words, it means, yes, the court has officially deemed that the debtor owes you, the creditor. Now, again, you might say, well, I don't loan money. I'm not a bank. I'm not a creditor. But in terms of debt collection, if you are owed money, you're the creditor, whether it be as an accountant or as an attorney or as a white label partner. So just make sure we have the vocab together. This program is really designed to equip attorneys, but it can work well for all of us that are business owners with the knowledge and skills needed to navigate the 5 critical steps in the collection process. Investigation, step 1, pre-suit collection, number 2, compliance, 3, securing judgment, 4, post-judgment collection. So we're going to learn where to find the debtor and asset information, because this is what's interesting. Some people say, oh, go ahead and sue me. It didn't matter. I don't have much. Well, that's fine. If they have income, we have examples where the debtor worked for McDonald's, literally worked for McDonald's, didn't have much income, but still a judgment was issued, and then 25% of that McDonald worker's pay came to the creditor. So even if someone has very meager income, we need to identify those assets, those sources of payment, and lock onto those. We talk about also how to get practical techniques for pre-suit collections, again, being compliant with FDCPA requirements, and how to secure and enforce judgments. So we have a broken down course content on this one because it's so important, how to get the vital debtor and asset information. And what you and I do, we're typically getting a really good data set, right? Because when they enroll as a client or if they enroll as a white label partner, we have a good data set. So unlike a lot of industries, we don't have to go hunt around and figure out who they really are. But there's that, the pre-suit collection strategies, again, compliance, compliance, compliance. We want to be compliance, getting a judgment, post-judgment techniques. So that is class 4. If you have any questions as we go through, let me know. Class 5, one of my favorites. And so this one is based around top 25 tips and tactics for debt collection. So again, if you're an affiliate, this probably doesn't matter unless you own another business, but as a white label partner, it's probably invariable that on occasion, people will owe you money, they won't pay. Happens to us. We have people that owe us money, they don't want to pay. So what are some top 25 tips? Let's read the description. Getting paid without running afoul of the law, compliance is number 1, right? It can be arduous and a time-consuming task. In an area replete with consumer protection pitfalls, the burden is on counsel, or you, the creditor, to maximize efficiency, keep in compliance, and successfully collect. Because the goal is to get the money from the people that owe you. If they breach the contract, they're responsible. People that breach contracts will almost always have an excuse. And they'll want to tell you about their excuses, or they'll want to blame it on you, why they didn't pay or why they didn't comply. But we're going to learn tips, including how to use social media to private investigations, staying in compliance. Again, you hear us talk about over and over, identifying common service of process and statute of limitation pitfalls. And we're going to talk a little bit about statute of limitations in a minute. What you may find out is that some people think that if the debt is older, that it can't be collected upon. But there's a backdoor way around that. And actually, we have a separate training class on that. But most states have a statute of limitations. In Texas, for example, it's 4 years for written agreements. It varies by state. And again, getting that judgment. That's the goal. Someone owes you and I money. We want to get a judgment against them because that's when the court system has officially said, yes, without revocation, that person owes you money. So then that positions us in a great position to go enforce that judgment to collect. Make sense? Okay, let's move on. Class 6. Now, this won't apply in every case, but you see a lot of small business owners, they'll go form an LLC. I won't go through as much detail here, but this is where we teach how to pierce the veil. So even though they have the LLC, they say, oh, go ahead and sue my LLC. It's not making any money anyway. What we're going to do is pierce that LLC veil and then be able to go sue the individual owner as well. And that's what that is about. Class 7, skip tracing. Let's say the person doesn't want to pay you and they're trying to get off the radar. So we got to find them. And so class 7 is called skip tracing. So it's where we locate assets, individuals, and information. So we learn about how to use social media and other tools, best results in less time, best practices. So in terms of breakdown of this course content, tips and tricks to find people, finding their assets. Because like we talked about, we want to find if they're a homeowner, that is awesome. Putting a lien against a home is one of the best collection strategies. Putting a lien against their business is another. But we need to identify their assets. Again, talking about using social media, remaining legally compliant, and different databases that can be used. So that is class 7. Anyone have questions as we go through this? Just go ahead and type it into the Q&A. What we're doing is we're preparing ourselves as creditors to collect money from the debtors that owe us money. And so instead of approaching it in a very elementary, informal way, what we have is the coursework here to be experts in this, so you get the maximum amount of money that's owed to you. Some of you, for example, are involved with our collateral support programs. You're buying and selling debt. Well, again, those are people that are not paying their obligations willingly, so these are good strategies to be familiar with. All right, class 8, the ocho, as Alfred likes to call it. Skip tracing and cyber tracking. And we were talking about skip tracing just a moment ago, but we're going to go a bit deeper into that here, looking at other resources and tools, how to find hidden assets from real estate, personal property, doing a bankruptcy search, getting a subpoena of their business records. Very, very effective. UCC search, judgment search, looking for cars they own, boats they own, maybe aircrafts that they own, the unclaimed property, getting with their banks and getting a lock on their bank account, and of course using the credit bureaus. All right, so that is class 8. Now we're on to class 9. And again, you might wonder, why do we talk about skip tracing and finding these debtors? Sometimes they're sneaky little devils and they don't want to pay, so they're on the run. So we want to have the ability to identify the party, locate them, because without that, how are we going to serve them? How are we going to collect from them? So class 9 goes deeper into that, including some things we hadn't talked about. Again, locating business entities, business tracing, skip tracing errors, making sure we know where they work, because we want to garnish those wages. Because in most states, you can get 25% of their wages. And so you don't get paid instantly, but over time. And we also look at some recent case law. Okay, so let's move on to class 10. So now we are at post-judgment. And we said earlier, kind of informally as we went through this, a judgment could occur by we filed the suit and we got a summary judgment. And that's typically what we'll file for, because rather than going to trial, we're just going to present to the judge, we're going to submit a motion, which is like a plea, a request to say, look, judge, there's a clear breach of contract. There's no reason to waste the court's time with trial. You just need to award us a judgment because the person owes the money. But once we have the judgment, then there's a whole art of collecting the money. So as it states here, after prevailing in a lawsuit and receiving a judgment, which I mentioned earlier was the goal, and you can sell judgments as well. So let's say that you get it to the judgment part and then you want to punt it off to someone else. Judgments sell really nicely because they're a court mandated confirmation that the debtor owes you, the creditor. So after that, the next step is the judgment. And so we go through that, early identification of assets, common asset classes, again, compliance issues, collections, asset-specific collection techniques, how to go after their wages, how to go after stocks they own, if they own LLCs, how to do garnishments, how to do levies, how to go get their cash, how to go cash out on their insurance if necessary, making sure that we find if they're moving money around fraudulently to pierce the veil, which we talked about earlier. If they're doing anything that's conspiracy, this can get them into criminal hot water. So it's more than them just owing you money. It could literally be them going to jail now. How we'll use subpoenas, injunctions, and orders and crossing state lines. So that is class 10. Class 11, again, more on post-judgment, just getting deeper into it, when to use garnishments, what you need to know to impose personal liability on business debts. Most of our agreements are written, and so if you're a white label partner, you'll see that the client is promising to pay personally as well as their business. So we kind of got that covered. And so good information there. We move on to class 12, more on post-judgment proceedings and collections. Clarifies that obtaining a final enforceable judgment is often just the first phase of civil litigation. Without effective enforcement and collection, a judgment is merely a piece of paper. This webinar provides an overview of the technical procedure and strategic considerations. And then lastly, class, oh no, I'm sorry, there's 14 classes. There was 13 originally, now there's 14, I believe. Class 13, advanced judgment techniques, how to uncover hidden assets, determine collection potential, and enforce judgment. Learn how to get judgment debtors to pay what they owe. We're going to use our experienced team to talk about effective methods for debt collection, the do's and don'ts, so you can collect your money, your owed money. If you're a business owner and people breach a contract, they owe you. Almost everyone will have an excuse of why they don't want to pay or why they can't pay, but they owe you. You have a responsibility to your business, to your shareholders, to your stakeholders to collect the money that's owed to you. So we'll get to know how to use post-judgment discovery and garnishments, understand debtor examinations, get them, if they lie, contempt of court. This will put their butt in jail, They don't want to do that, right? They need to comply. They need to pay you. And some people will go do the bankruptcy thing on you. And we'll talk about how to work around that. So now we're to the final, class 14. This was the last one we added, and I forgot about when I said 13. Because we talked earlier about statute of limitations. Each state has a statute for how long you can go after someone that has breached a contract against you. But I can tell you that we'll file cases that are 5 or 10 years old because there's some ways around it. So it's addressing time-barred debts. Credit recovery options change when a debt is older than the statute of limitations. Notice what it said. It didn't say, oh, you can't collect it anymore, because that's not true. But the process is different, and that's what we're talking about here. So in these cases, creditors must be accurately aware what they can and cannot do to attempt recovery without breaking the law. We never want to break the law. We want to be legal. So we'll talk about how to steer clear of violations when collecting old debt, and some great information. Wow, that was a lot. And so let's summarize. I'll go back to the top. Today's topic is an overview of the curriculum that we've assembled to help you as a white label partner and or a debt buyer, debt seller, collect money owed to you. Because what I see is we've had some white label partners, including Bernard on here, and Bernard over the past year has had a number of people that breached agreements with him. He's owed, we'd have to look at those numbers, but I suspect it's certainly in the 6 figures, probably mid 6 figures. So let's just say $250,000, I'm going to guess, is owed to Bernard from, because he's a big producer, from clients last year that breached agreements with him. Well, we need to have a strategy to collect the money that's owed. When a contract is written and agreed to, then both parties have promised to follow it. I don't want you to be of the mindset that if the other party quits or breaches, that somehow you're left out in the cold. You're not. There's a whole legal system called business litigation that if we follow correctly, you can collect. Now, will you collect every dollar owed? Probably not. But certainly we can collect a lot of it. And in some cases, we can collect more than what was originally owed because of late fees and other penalties, if you will. So who has questions for me regarding today's topic, which I know for several of you is an important one? We got Tony on here. Tony owes us money. So Tony just probably learned about how we'll be resolving that with him. Bernard, I mentioned, has a lot of people that owes him money. So now Bernard has an understanding. We got Andrea on here. She has a client, Patsy, that I believe is in default to the best of my knowledge and owes Andrea. So this is good, relevant information if you're a white label partner. But frankly, I think this is important information that every small business owner should know, because there's just, it's rare that a business, unless you're cash only, won't have receivables. And invariably, some of the people that owe you money, the receivables, won't pay. So we need to know how to resolve this. This is practical information. When I worked at the SBA, I started teaching this at workshops. We had a 14-county area, and I'd go out to some of these areas, some were more rural, and it was like amazing. A lot of small business owners have never been taught these practical legal techniques of how do you get the money in when you've been breached. You could just run an auto mechanic shop and someone doesn't pay you for fixing a flat tire. Of course, based on the size of the debt owed would alter our strategy. But we have a litigation practice that we can assist in some cases. Of course, we have our own issues of people that don't pay us that we have to resolve, but I think it's important that you, as the CEO of your business, understand that you have creditors' rights. Paulie's on the line here, and no, I'm sorry, it wasn't Paulie. Paulie is on the line, but it was another one of our white label partners. I'm forgetting who it was now, but had a client that signed up and then failed to participate. And so we were going through some of this. So it's invariable. People sometimes lack, it seems like, moral guidance. They'll sign an agreement and then somehow they have a reason and excuse to not follow the agreement. A lot of times it's illiteracy. They think, oh, I can enter into an agreement. If I just change my mind, I can just change my mind. Or they'll come up with nonsense like, well, there's a 72-hour rescission. I changed my mind 72 hours later. That's all nonsense. It's all about what's on the paper, what's in the contract. All right, so we got a couple questions. Aziz is asking about a landing page. Yes, so any of you that are an affiliate, you get a landing page automatically, free. If you're a white label partner, and that ties to this here, if you're a white label partner, Scott Stroud, our Chief Marketing Officer, can set up a landing page for you that would allow clients to e-sign. Having clients e-sign is best practice. You have the highest conversions. You've heard me talk about Jeff Sokol, S-O-K-O-L, many times. He's the record holder. 400 client enrollments in a 30-day period. 400 client enrollments in a 30-day period. Had just a bit over 53s, between 53 and 54% conversion. How did he do that? He didn't talk to anyone. He had Scott on our team set up a landing page. He drove people to it. People e-signed, and that created a fortune for that man. So, Aziz, if you need a landing page for free, become an affiliate. If you need one as a white label partner, then of course, Scott can build one for you. Thank you for that. All right, so then I mentioned Paulie a moment ago. So he's got a question. If a client is in family court judgment status, such as child support default, and it's affecting their opportunity to get access to capital, what can be done? We'll work around it. So I would enroll the client, and then we'll gather data, and we'll create a funding plan for them. Similar, Paulie, to a client I was working with this morning with Chanel. Chanel's got a client that enrolled, looks pretty credible on paper, but we came to find out he's not filed taxes personally or business for the past 2 years. So it's not unusual that when we go through the process to build the loan package, that we might find that we need to alter where we're going to go for the capital based upon what the clients have or have not, their strengths and weaknesses. And in some cases, we need to work to address those. Now, he doesn't necessarily need to file the back taxes to move forward in the process, because different sources of capital have different underwriting criteria. All right, so who else has questions, comments, concerns on today's topic? This is a very practical one. All right, Timothy's asking about how we're going to implement this. That's a great question. So if we were to do this together, we would need to know, we would need about 2 days in person. And so what we're thinking about doing is setting up a 2-day in-person workshop so we could go through the 14 classes together, have nice dialogue, exchange. And so that's one option that we're considering. So depending upon the feedback that we get from each of you, we may in fact set up like a 2-day session, and we could set it up in your area, our area, wherever. But the bottom line is to go through the 14 topics if that's of interest. So that's one option we're considering. If any of you are what we call our debt buyers, in other words, you're buying collateral support program debt portfolios and then reselling it, we're going to obviously be assisting you with this automatically. And hopefully you'll allow us to do the litigation for you so you don't have to climb this learning curve. But again, I think it's relevant. Anyone that's an owner of a business, and obviously all of you are, even if it's an informal sole proprietorship, you're probably going to run into issues where people owe you money. And that means that you're a creditor, there's debtors that owe you money, and these topics are extraordinarily relevant and targeted to this. All right, so anyone else have any questions or comments on business litigation, creditors' rights, training curriculum? I know we'll be over at the courthouse tomorrow filing a whole bunch more petitions for breaches. Many of them are from you all in the field where you have us handling the litigation for you. They range from, I think the smallest suit we have to file tomorrow is with the gentleman that did not pay his refundable deposit. We did 0%, set up 0% financing for him. He paid 3 payments, $300, and he stopped paying. So he owes $2,200. So that's the smallest suit we're filing tomorrow. And then we have some that are 6-figure suits that are owed. Sometimes, and I'll close on this, sometimes you don't know how big the claim is, how big the suit is, until we get down into the process and do discovery. Like our white label partners, sometimes we don't know how much they might owe us until we start getting their bank records and doing depositions. Sometimes with clients, they've received funding that they've not disclosed to us, and we don't know how much they actually owe us until we've gone through discovery, and that's okay. So we'll file a petition for a presumed amount, but it could very well change. In some cases, we have to literally change the courts, because if we get above 250,000, we'll normally go to the federal court instead of district court. So that gets a little more advanced, but let's get back. All right, so Jeanette is one of our debt buyers, and that's right. So Jeanette, so this is very relevant to you. And I think sometimes, and I'm not talking about Jeanette, and I'll close on this, that sometimes people will buy the debt portfolio, but they're somehow not of the mindset that now they're owed over $100,000. It's real debt that are owed to them. So Jeanette, of course, is sharp enough. She knows that. And so Jeanette, we can either help you. We have our litigation program, and we can take care of it for you, or you can do it yourself. If you're going to do it yourself, I would encourage you, Jeanette, to consider coming to the 2-day training class so we can get you up to speed by going through all of this. We're not attorneys, we're paralegals, and so we can't give legal advice, but we certainly can teach these legal strategies and processes, which are in fact what we follow. And you can see that there's a fair amount to it. But we have one debt buyer, JP, he's bought 3 portfolios in the past week and a half. And so he sees the money-making opportunity of buying and selling defaulted debts. So if any of you are looking at enhancing your retirement, building your wealth by acquiring and then liquidating portfolios, this is really good information if you're wanting to do it yourself. But if you have individual questions, I encourage you to follow up with us. Thank you all for your time this morning. We will see you back tomorrow morning, Tuesday morning. Have a great day. Thanks. Bye.